Good morning, everyone, and welcome to our webinar this morning called Planning for the Future, the Adult Guardianship and Trusteeship Act. I see some people are still joining, so we'll just do a bit of an intro before we get into the meat of things as people keep coming in. So if this is your first kind of part, this is actually a 4-part series, and we're at the final part today. So our first one focused on mental capacity or decision-making capacity, and then we focused on making a will. And then 2 weeks ago, we did a presentation on personal directives and enduring powers of attorney. And then today we're going to finish up with the Adult Guardianship and Trusteeship Act. Now, if you've missed the first 3, don't worry. They are all available to watch on demand on our YouTube channel. We're going to post a link to that in our chat. Keep watching the chat throughout today's presentation. One of my team members, Natalie, is behind the scenes. She'll be posting lots of information in there. So do check some of that out. And I guess I should introduce myself. So I'm Jessica Steingart. I'm one of the staff lawyers here at the Centre for Public Legal Education Alberta, or CPLEA for short. And if you're not familiar with our work, our goal is to make the law understandable for Albertans. So we are a nonprofit. We serve all of Alberta. And we provide legal information and education through a variety of ways. So we have info sheets, videos, webinars, booklets, articles, websites, etc. So we have lots of different resources available, and they're all free. And at this point, I'd also like to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. So I am here in Edmonton in Treaty 6, but we know that people are joining us from across the province and even beyond. So welcome. Okay, just a quick disclaimer this morning. So we are here to provide you with legal information. We are not able to give advice, and this presentation is not intended to give legal advice. I'd also like to acknowledge the generous funding provided by the Alberta Law Foundation and the Department of Justice Canada that make presentations like this one possible. A few other housekeeping items. We are recording today's presentation. As I mentioned, the other 3 in this series are available on YouTube, and within about a week, this one too will be available for you to watch there. And the second kind of housekeeping item is that we are going to make sure we leave some time for questions at the end. So if you have questions throughout the presentation, you can throw them in the Q&A little chat thing there, but we will save time at the end and we'll address all the questions at the end. Okay. Let's jump into the meat of everything today. So where are we going today? What are we going to do? First, I'm going to start with a bit of an overview of the Adult Guardianship and Trusteeship Act, and I'm going to refer to it as the AGTA because it's a bit of a mouthful to say otherwise. So I'm going to use the acronym AGTA. And after that, we're going to move into a panel discussion. So you'll see some faces on your screen. I'm going to hold off introducing them for now, but they will be joining us for our quite a hopefully robust panel discussion about some different questions about the AGTA. But before we get in, I think we have a quick poll we're going to throw up on your screen just to get a sense of kind of where everyone's at today in terms of their knowledge of the AGTA and our resources. So I think that should pop up on your screen. There we go. So there's 2 questions there for you. Okay, so it looks like we've got a lot of appetite for learning this morning, which is exciting. Okay, good to know. So let's start with the Adult Guardianship and Trusteeship Act. So the Act provides a variety of ways for an adult to get help making decisions. The current version of the Act came into force on October 30th, 2009. And it outlines some different tools that we can use. There's several different tools that are kind of described in the Act. And really the right tool depends on the adult's capacity and the type of decision being made. So I've highlighted those two words, capacity and type of decision, because really we've been talking about those concepts throughout the entire series. So in case this is your first time joining us, I'm going to take a minute to do a quick recap on capacity and the types of decisions, because that really is an important starter for our conversation today. So again, what is decision-making capacity, or sometimes we call it what is mental capacity? And it's kind of a two-parter definition. So the first part is the ability to understand information that relates to making a decision, and the ability to appreciate the reasonably foreseeable consequences of making or not making the decision. So that's what we're looking at when we're assessing decision-making capacity. And again, that definition, not in those exact words, but that concept comes from the AGTA itself as well. Okay, and another little bit more review on the types of decisions. So we've looked over the last few webinars as well about types of decisions, and we've categorized them into two ways, and that's personal and financial. So when we talk about personal decisions, we're talking about healthcare, living arrangements, who you can associate with, your social activities, education, work, and then legal proceedings that are not about your finances. When we talk about financial decisions, we're talking about anything that has to do with buying, selling, managing, or protecting property. So this, and property being anything from your home, your money, like even cash, your investments, your belongings, etc. So we've looked at this, and we looked at this in the first part, and we looked at this last week talking about personal directives and enduring power of attorneys, because really those two documents use this divide as well. We know that a personal directive has to do with personal decisions, and an enduring power of attorney has to do with financial decisions. So now that we've got those kind of two concepts, reviewed them again, let's dive into some of these tools then that are described in the AGTA. We're going to start with the decision-making tools, and you'll see an arrow on your screen because we're going to look at these tools in order of sort of decreasing capacity. So as someone's capacity diminishes, then the different tools are available to them. So under financial decisions, the first tool is called the temporary trusteeship order in urgent cases. So this comes into play when an adult has no capacity and they are in danger of financial loss. So if someone does not make, an immediate decision, they might suffer serious financial loss. And so we can get this type of temporary urgent order, and it's good for 90 days. So it's supposed to relieve that urgency. It might lead into then applying for a more permanent trusteeship order. And that is where an adult has been assessed as incapable, but they don't have an enduring power of attorney. Because of course, if someone has an enduring power of attorney, we can activate that document. But if they don't, then we need to go to court to get a trusteeship order. And part of that application process calls for a capacity assessment, which is a formal assessment and a report done by designated capacity assessors. And we did talk a bit about capacity assessors in our very first session on mental capacity. Some of you may have heard of something called an informal trusteeship, and that is an option, but it's not a kind of blanket option. So it's an option if you're dealing with certain agencies and you want someone to help you manage your payments from certain agencies. Those agencies will let you set up an informal trusteeship, but there's no kind of standard rules about them. It really depends on the agency that you're working with. So I haven't outlined it here because, as the name suggests, it's an informal option, but I just wanted to flag that. So those are the financial options. So kind of skinny. There's only two of them. We have a few more tools though when we move into the realm of personal decision making. And the first one we'll start with is called a supported decision making authorization. And this is a form that an adult with good capacity can use to name up to 3 supporters. And so you can see we're starting with this one with an adult having good capacity, but still wanting support making decisions. This is important to know that in using this authorization form, you don't have to go to court. So it's a form you can fill out and activate it. So you might be wondering, well, where might that come in handy? Well, it can be helpful where a capable adult, so they are able to make their own decisions, but maybe they're facing a really difficult decision, or maybe they have difficulty communicating in English or other communication difficulties. Maybe they have a mild disability, or maybe they just need help for a little while due to a temporary condition. And so while they are capable to make their own decisions, they just want that support in doing so. It's important to note that any decisions made by the adult, which we call the supported adult, are the decisions of the supported adult. The supporter is not making decisions for them. Okay, so again, in order of decreasing capacity, the next tool is called a co-decision making order. And so it has the name order in it, or the word order in it. So this does suggest that we do need to go to court to get this type of, to activate this type of tool. So in this case, an assisted adult has some capacity and they agree to this type of court order. So that's important. In this case, the adult has to agree to this court order coming into play. This is helpful where an adult cannot make personal decisions on their own necessarily, but they could with the help of another person. And so that's the co-part. They're making that decision together. This also would come into play where you don't have a guardian or a personal directive, because of course, if that was the case, we could use those tools instead. When we talk about co-decision making orders, I would also just quickly note that the court can say what types of decisions it covers as well. So it may not be all types of personal decisions. There may be some carve-outs if necessary. Okay, specific decision-making is a tool that healthcare providers can use when they need a decision right away on treatment or placement. So this is actually a very narrow, this tool has a very narrow scope. So it's only used where an adult does not have capacity, they don't have a guardian, they don't have a personal directive, but we need a decision about healthcare or temporary admission or discharge from a residential facility. So again, very narrow application. And in this case, the healthcare provider can choose a relative to make that decision. Now, it's not just any relative. There's a list in the AGTA in order of priority. And so it starts with a spouse or an adult interdependent partner. And if the person doesn't have a spouse or an AIP, then we would move to the next relative and so on. Okay, this is a new slide, but we are still more and more diminishing capacity here. So just like we saw a temporary trusteeship order, we also have a temporary guardianship order, again, where the adult has no capacity, but they are in immediate danger of death or serious physical or mental harm. And again, this is a temporary order for 90 days. It may need, there may be a need for then a guardianship order, which would entail a capacity assessment. And again, where the adult is assessed as incapable, they don't have a personal directive. And so we need a court order appointing someone to make a decision, to be able to make decisions for them. So those are all the personal decision-making tools as well. Now, I just want to highlight one quick thing. We've talked a lot about, this relationship between an adult who needs support making decisions and then someone actually helping them or supporting them in making, or even in some cases, making those decisions for them. Now, I want to just note that that person who's helping or has that role of supporting, they have legal responsibilities as well. So the AGTA not only describes the different types of acts, but it also sets out some of the responsibilities for those people that are assisting an adult. So if you are being asked to, be a guardian or be a co-decision maker, it's also important for you to understand what your responsibilities are and some of the kind of legal rules that you must follow. So I just wanted to flag that there. Okay, I want to move into the discussion here, but I think I have 2 more slides here. I've talked a little bit about this already, but question, what happens if someone has a personal directive or an enduring power of attorney how does that interplay with some of these tools we've just talked about? I've already mentioned what a personal directive and an enduring power of attorney are a little bit, and we talked about those 2 weeks ago. And really the kicker is if you have these tools, they can be activated. And so some of these other tools under the AGTA may or may not be necessary. The benefits of having these legal documents in place, a personal directive or an enduring power of attorney, is that you don't need to go to court. It allows you to choose someone to make decisions for you. And it also allows you to talk to your decision maker about your wishes before the document needs to be activated. So if you don't do those things, I mean, as we've just seen, there are tools for someone to help you make decisions, but it may not be the person you would have chosen, and they may not know what your wishes are. And so they'll have to make decisions based on what they think is best for you. So again, coming back to what are the benefits of putting some of those legal documents in place, and so that's where we are at. Okay, I lied. I only had one more slide left. So that means it is time for a panel discussion. So I'm going to do a quick intro of our panelists. So first up is Amy Abbott, who is a partner at Emery Jameson LLP. So Amy is a lawyer and partner at Emery Jameson. She practices in the area of wills and estates, and she advises clients on a range of estate planning and estate administration matters. And as well, a portion of her practice is dedicated to disability law. And she regularly advises clients on guardianship and trusteeship matters, as well as planning for dependent adult children. So it's easy to see why Amy is joining our discussion this morning. So welcome, Amy. We also have Lincoln Marr, who is with the Office of the Public Guardian and Trustee. Lincoln obtained an undergraduate degree and law degree from the U of A. Lincoln started working for the public trustee in 1990 and then was seconded to the Public Guardian's office in December 2010. So they used to be more separate than they are now. And he moved to the Public Guardian's office in December 2010 to assist with the implementation of the AGTA, which remember I said it came in 2009. So Lincoln was around that time. Lincoln became a permanent member of the Public Guardian's office in December 2011 as a review officer and trusteeship specialist. And Lincoln currently is a review officer and trustee specialist with the now integrated office of the Public Guardian and Trustee. So welcome, Lincoln. And we have a third person this morning as well, Susan Wright, who is also with the Office of the Public Guardian and Trustee. Susan is a supervisor of trust administration. Her role with the Public Trustee's Office is to supervise the team that reviews all the trusteeship referrals and assets, which include real property or homes and whatnot that their represented adults own. Susan provides consent on behalf of the public trustee on all trusteeship applications and supervises the asset investigations that are handled by the Office of the Public Guardian and Trustee. And this is, I didn't know this, but asset investigations include going out to the client homes, completing an inventory, photographing their assets and their residence. And in some cases, assets such as jewelry and collectibles will actually be brought back to the Public Trustee Office for safekeeping. So welcome, Susan. So we have an abundance of experience on this call this morning. So I'm excited to get into our questions and we'll dive right in. So first question, what is the role of a lawyer or the Office of the Public Guardian when it comes to decision-making under the AGTA? And Amy, I'm going to turn it over to you to start.
Sure. Thanks, Jess. Good morning, everybody. I think first and foremost, the role that a lawyer can fulfill with these applications is to assist with having them drafted and prepared. They do involve quite a bit of paperwork in terms of the application forms that are required to make an application for guardianship or trusteeship or both. So sometimes having a lawyer assist you with that process can be very beneficial. Some people find it a bit daunting and overwhelming to handle on their own. And as part of that, a lawyer can take care of the steps required to have that application submitted either to the Office of the Public Guardian and Trustee if it's going by way of a desk application, or directly to the court if it's going by way of a hearing. And maybe we can touch on that a bit later if we need to. And then I think aside from that, a lawyer can help clients to understand what kind of order is needed, which decision-making option is the most suitable in the circumstances, to advise, what would be appropriate and what you actually need in place. So a lawyer can help you to understand the differences between the options that are available and which one might apply to your situation.
Perfect. Lincoln?
Well, so since the OPGT is our office's legislation, so to speak, one of our biggest roles is kind of providing information to the public when they, have situations about decision making and persons with potentially diminished capacity and they're not sure what to do. We get a lot of calls and we kind of are able to kind of walk people through the legislation, through the different options. Again, stopping short of the legal advice, like you should do this, but just outlining what the act allows you to do in different situations. We always say, if you're not sure, do consult a lawyer and so on. As well, the Office of the Public Guardian Trustee, in terms of the decision-making options that you outlined before, Jess, our office, the Public Guardian, is on that list of persons who can make specific decision-making decisions about healthcare and about residential facility placements. We're way down the list after all the family type of thing, but there are people who either have no family or no one knows who the family is. So to be honest, that's a significant role that our office plays, making those specific decision-making decisions for individuals. And again, not a role that we mind, mainly because it prevents, because that option exists, and if that's the only decision that has to be made, then it prevents potentially our office having to make a full guardianship application for those individuals. If all they need is a decision of where they're, if they can be moved from acute care hospital to a potential appropriate facility or whatever, we'll do the appropriate due diligence to make sure it fits all their needs and stuff, but then we can make that decision. And as long as then all their needs can be met otherwise, then you might not have to go to the kind of last step of a full-blown guardianship application. And as well, of course, our office does come in at that step as well. If it's appropriate for the public guardian or the public trustee to act for an individual, either as guardian or trustee, then potentially our office will act in that capacity.
And those, when you're acting, those are the represented adults we were referring to in Susan's kind of intro there, correct? When we talk about a represented adult by the Office of the Public Guardian, that would be an individual that you are supporting or making decisions for?
Yeah, that would be, represented adult is the term used in the legislation for anyone who has a guardian or trustee, but yeah, that's what Susan was referring to, the individuals who the public trustee might act as trustee for. They're our represented adults.
Perfect. Susan, did you want to add to that?
Lincoln did such a great job. I don't have to add too much. On the trusteeship side, I think the thing that confuses people is, I'll just touch a little bit more on that informal part that you talked about. That can be specific benefit programs, and that, say, for an income source like AISH or Alberta Seniors Benefit, those programs have specific informal trusteeship or informal trustee financial management programs. On the other side of it, when it comes to the AGTA for the public trustee, for us, there is no kind of middle ground. It's trusteeship is all or nothing. There's no kind of you're half in and half out. If you're acting as trustee for somebody, then you're in it with your court order. And there's no half measures, unfortunately. It's just you are the trustee. And that's the role that the public trustee plays. It's a permanent role, likely for the lifetime of the adult. It is a rare circumstance that the public trustee is actually discharged. We may have situations where a family member might step in. Sometimes we get individuals, their adult children are quite young. They don't want to help with finances, or there's family discord. Sometimes once we've sorted out those problems after 2 to 5 years, family might step in, but the public trustee is typically trustee for the rest of the adult's life.
Excellent. Thank you all for that. I feel like I have so many questions coming off of that, but I am going to try and stick to the script here a little bit. Okay, so our next question is, what is the difference between personal and financial decision-making, which we've already talked a little bit about, and why is this one important to understand that difference? And Susan, I'm going to start with you.
I think the big difference, and you would think that people wouldn't be confused about either personal decision or a financial decision. When the public trustee is involved, we're all about the money. And it might sound a little bit cold. We do focus just on the money that the adult has. So for example, if a guardian or the adult wants to move into a specific rental accommodation, whether it's a long-term care center or apartment rental or a house rental, we look at the money that they have available to them to pay for that accommodation. If they don't have it, we're not a public funding agency. We can only expend money that the adult actually has in their trust account. We do a budget based on their income, their expenses, and the assets that they may have or that we might have to liquidate. They could have investments that will say, well, you need to liquidate that investment in order to live in this location. So that's some of the things that we really try and separate out is what are the adults' needs as it pertains to the finances? Do they have the finances, the money available to pay for that specific place that they're going to be moving into? So I think it's really critical that people understand the financial piece is totally separated from the personal, not just the living, but also their personal needs for groceries if they have any habits, drugs, alcohol, tobacco, those kind of things. You still do have to take some of those things into account. We can't stop an individual from, say, buying alcohol, even though the alcohol might be bad for their health. They can still take money that we give to them and go buy whatever they want with it. So we can't control that piece of it. And some people think that, well, the trustee is going to control the behaviors. Again, that's the personal side of it. And we can't control that by controlling money.
Perfect. Thank you, Lincoln.
I don't really have too much more to add other than, you know, it's important mainly because in Alberta, those things are divided. In other provinces, you become a committee or when you act on behalf of someone, often you have both personal decision-making and financial decision-making powers kind of granted to you in one big bundle. But in Alberta, still, we have that division. Trusteeship is financial, guardianship is personal decision-making. And because that division still exists in our legislation and our laws and so on, it is important to understand, even though, you know, in day-to-day living, a lot of decisions kind of straddle that line, but it is important to understand that difference in law still exists in Alberta.
Perfect. Amy?
I think all I would add in terms of the importance of knowing the difference between the two areas is how it informs what kind of order you may actually need for that particular person. You know, sometimes we run into situations where the capacity of the person is such that, you know, maybe they are able to make decisions about most of their personal matters, but it's really the financial side of things where they need that decision-making support or representation, or vice versa. So sometimes just being aware of what are the decisions that actually need to be made for the person. You know, sometimes it may be that only a guardian is needed where there is someone informal appointed as, for example, a financial administrator to handle AISH income, because that's really the only income or asset the person has. So just knowing the difference between the areas of decision making, because people, I think, can conflate guardianship and trusteeship and sometimes assume they need both when maybe perhaps they don't.
Excellent. Thank you all for that. Okay, next question. Do people use these decision-making options that we've discussed? So not just the guardianship and trusteeship orders, but also some of the, the authorization and the co-decision-making orders. If not, why do you think they don't? And if yes, which ones are most common? And we'll start with Amy.
Okay. In my experience, the most commonly used are guardianship and trusteeship. And I say that, though, from the perspective of a lawyer who's probably only being asked to assist with those kinds of applications. So it may not be representative of how common co-decision making and supported decision making are. I think in particular because supported decision making, likely you wouldn't need the assistance of a lawyer necessarily because it's an authorization form. Co-decision making you may because it's an application for a court order. But in my experience, guardianship and trusteeship are the most common that seem to be used. I think perhaps the reason that co-decision making, one of the reasons it may not be used as much, is that, at least in my view, it's a bit of a gray area in terms of you still have to have a capacity assessment, and it has to confirm that the person has some capacity over these decisions. And I think sometimes people find that piece confusing, where someone might still have capacity but need that kind of support. And so the default seems to be to try for a guardianship order instead, if you have a capacity assessment that supports that. I think one of the other reasons the co-decision making option may not be used as much, at least in my experience, is that the represented adult or the supported adult can actually withdraw their consent to that order, which then terminates that decision making option. That's one of the ways that it can no longer have effect. And I think sometimes perhaps that when people are aware of that, they're perhaps more reluctant to explore that option. But I'm curious for Lincoln and Susan's comments on this in terms of what they see actually in terms of how prevalent the other options are.
Lincoln?
Well, Amy is entirely correct. So obviously supported decision making doesn't really involve, wouldn't normally involve a lawyer or even our office. So we're really not sure how often that is being used. Specific decision making, again, if it's there, if the medical facilities are asking family, again, we have no way of keeping track, but certainly our office. So the number of, if you judge by the number of times they get to the bottom of the list and ask us to make decisions, which is, yeah, and again, that's just our office in Edmonton. I have no idea about what they're doing in Red Deer or Calgary or, but I can assume it's similar to the volumes that we get, from the care facilities and so on about healthcare decisions, these one-time healthcare decisions. And of course, for some individuals, you can make multiple one-time decisions for them if they go into hospital for different reasons and so on. Again, and still not have to get that guardianship order. So the specific decision making is, I hate to use the word popular, but it is used quite often, judging by how often our office is asked to act on individuals. Amy is 100% correct about co-decision making. I think the last I recall hearing in terms of statistics for our office is that co-decision making, some of our offices in the province have never seen a co-decision making application, and it's 2009 to 13 or 14 years ongoing, and it's exactly for the reasons that Amy says, is that particularly with the adult having significant impaired capacity, but that means where is that line? Well, the legislation doesn't necessarily define where that line is, and again, as Amy said, since the adult can withdraw at any time, and it is still the court process, so it could be a lot of work, a lot of paperwork, a lot of stuff, and the adult says, no, I don't like this anymore once the first decision is made and they don't like it, type of thing, right? So co-decision in my experience is not very popular. And again, we've got to make sure co-decision only relates to personal decisions as well. Again, as Susan said before, there's no middle ground for trusteeship, right? So there's never a co-decision making for trusteeship. So again, the most popular, because that's really the focus of the legislation in a way, is the guardianship and trusteeship applications. And the reason that the legislation was put in place is to, we tried to refine that mechanism of formal guardianship and trusteeship applications, trying to preserve the dignity and beliefs and wishes and values of the adult as much as possible, and so on.
Perfect. And Susan?
I was just trying to think of what the majority of applications, I think Amy's correct. The majority that we see are either straight guardian, trusteeship, or both. SDM, we sometimes get a lot of inquiry calls about SDM and how to use it. That we don't track it. We have no mechanism for that. But I want to touch on the co-decision maker. I think in my time, so I've been in this role, actually took it over from Lincoln when he left in 2010. And I think in my entire time, I've only maybe seen 2 or 3 co-decision maker orders. The other thing with the co-decision maker order, and it's kind of a fault of the legislation, it's not maybe a fault, it's just not drafted in a way that, let's say a trusteeship order gets issued, then the co-decision maker order is canceled, because then it says a person doesn't have capacity at all. So that piece is gone. So there's no, I wish there was a co-decision maker for, financial matters, because sometimes that might help to cover some of these. Instead of doing a full court application for trusteeship, you could have a co-decision maker for finances. But the way the legislation is right now, once that trusteeship order is issued, the other one disappears.
Interesting. That's good to know. Okay, I'm going to keep us moving because we have a few more questions to get through, but that is such great information. And I will just say the reason I asked that question too is, we look at the legislation and we outline these options, but practically speaking, what does that mean for people? So I'm really glad we got to have that discussion. Okay, our next question, what do you wish people knew about these options? We've talked a little bit about that. It's kind of come out a little bit already, but is there any, other sort of benefits that you wish people knew about these options? And I am going to start with Susan.
Oh, geez. I just wish actually people would draft their POAs and their personal directives. That's really what I wish they would do. I don't know actually what I could say about this. I think for me, it's just for people to have a plan in place before they actually lose the capacity. These options, it is such an expensive process, whether you do it yourself or you have a lawyer draft the documents for you. It is an expensive process. And if you don't make that plan in advance, yeah, I just don't know what else I would add. I think we've had some really fulsome discussions from the previous question. Maybe Lincoln or Amy would have some more to add.
Sure, Lincoln.
Just kind of expanding on what Susan said. Yeah, I do wish that, when people, and again, it goes to advanced planning, when people are humming and hawing saying, oh, I don't want to pay a lawyer $500 to do a will and enduring power of attorney and personal directive. If they could see into the future and see that, okay, if you don't have these documents and you become incapacitated, and how much trouble and how much work and how much money it is for someone else or for yourself to get those documents for your elderly parent or whatever, it is inevitably less work and less money to do some advanced planning than to have to make use of any of the options under the AGTA to obtain specific, to obtain substitute decision making for an individual.
Awesome. Thank you, Amy.
Yeah, I really would just echo what Susan and Lincoln said. Though that was really the comments I had on this question as well. Is that I think, and it flows from our discussions at the last session as well on powers of attorney and personal directives, that it's just so much more cost effective, less time consuming to have a personal directive and power of attorney in place that actually appoints the person that you want doing these things as well, rather than leaving it to someone to apply. And I think there are misconceptions as well, which Lincoln had touched on, I think, at our last session, that sometimes people think, even if there's not a personal directive or power of attorney, that sort of the next of kin can step in to make some of these decisions informally. And that's really not legally true. And, so sometimes people aren't even aware of this whole guardianship and trusteeship regime that when there isn't a personal directive and power of attorney. So I think I'm just echoing really what Susan and Lincoln said, is that would be what I would want people to truly understand, is what is necessary if you don't have those planning documents in place.
Perfect. And we did talk a lot about that last time. So if you're curious about personal directives and enduring power of attorneys, please go and watch the last session. And one of the things that comes out of that too, you'll see from our discussion last time, is that this is not, we can sometimes conflate decision-making capacity with getting older, and that is not the case. And so, even someone who's just turned 18, there's value in advanced planning then, because, we never know what's going to happen as well. So I just throw that in there. Okay, let's move on to our number 5. So what about in emergencies? Who can make quick decisions? We've talked a little bit about this already. So if Amy, I'll start with you if you want to add on anything.
Sure. The specific decision making I know has come up, and I won't comment too much on that. I'll maybe defer to Susan and Lincoln on that, because I think they have a lot more experience with it than I do. And then the other two that I'm aware of and have utilized before, helped clients to utilize, are the applications for urgent orders, which you had covered in the PowerPoint, Jess. So for situations where there's a concern that an adult may lack capacity and might be at imminent risk of death or physical or mental harm, an application can be made to the court for an urgent guardianship order. The benefit to that is you don't need a formal capacity assessment. You just need some evidence to support that this person likely lacks capacity. And then, of course, you need to have evidence to support what the actual risk of harm to them is if a guardian isn't appointed. And you can usually obtain them on quite a quick timeline, because the timelines for giving notice of the application are much, much shorter. I believe it's still 2 days notice that's required. So, if you have a really urgent circumstance, you can get into the court to get this kind of temporary order in place. And then there's a similar process to get an urgent order for trusteeship. And the standard is similar. It's just a risk of serious financial harm. There has to be some evidence of that. So, they are mechanisms that do get used, often in very unfortunate and sad situations, but they are there. And in my experience, the court is very receptive, when they feel that the situation warrants that kind of temporary measure being put in place.
Perfect. Thank you. Lincoln?
I don't have anything to add. Amy covered it very well. Those are standardly what, in an emergency situation, again, for medical decisions, you have the specific decision making, and then you do have the urgent order provisions in the legislation.
Perfect. And Susan, did you have anything to add as well?
I'll just add one little piece to that, and Amy might know a little bit more about the other side, but on trusteeship, if we do an urgent order, the urgent order is only good for 90 days. Then you have to go back to court. Now it can be extended for another 90 days, but then after that time, you have to do your regular application. I think it's the same on the guardianship side, but I'm not sure because I don't usually see that. The other part too, when we do an urgent order and we're serving an individual, we only have to serve the adult. We don't usually have to serve anybody else. That's why the timeline is much shorter. I know we've had a couple of referrals where the adult's property was at risk and they were in the hospital. We have gotten an order within 3 days of receiving that referral to our office. So the court turnaround time can be quite fast. So it's important to keep in the back of your mind that these orders are only good for 90 days. And they're typically very limited on what your authority is, because your authority is usually just to protect and preserve the property. It's usually property that we're dealing with.
Excellent. Amy, did you want to confirm it's 90 days for guardianship and then
Sure.
an extension too?
For the guardianship, it's the same initial period, 90 days. I believe it can be renewed for up to 6 months or extended for up to 6 months beyond that initial 90 days. Usually, though, you of course would have to return to court to speak to why that extension should be given. And sometimes it may be a situation of more time is needed for someone to actually pull together an application to be appointed on a long-term basis. So there is that option to have it extended, but typically the court would not extend it beyond that. I don't believe the Act limits to the 90 days and then a further 6 months for the extension.
Perfect. Thank you. And the other piece, we had mentioned this already, and Amy mentioned this, and we've talked about a little bit, is that, in this question too, we are talking about which tools we can use in emergency, because of course there isn't that default of just next of kin. And that common misconception we'd mentioned, that people think, well, if I can make a decision, my spouse can or my child can, but that isn't legally an option here. So that's why we have to talk about these different tools. Okay, let's move on to number 6. Kind of a catch-all. What other important information is set out in the AGTA? We've talked a lot about the decision-making tools, but is there other important information that you would like to highlight? And I'm going to start with Susan on this one.
I'm just trying to think of other information that's important. I think it's just important to make sure that you do read the AGTA in its entirety, and make sure that when you're applying for a guardianship application that you read those specific sections, because it really does actually lay out sort of what the requirements are within the Act and the legislation. And then again, on the trusteeship side, it's really only 2 sections that you're focused on. One is section 46, which is your standard desk application, and then section 48, which is your urgent application. And on our side, on the trusteeship, we really focus on making sure to help individuals understand what each section means and how they should be doing the applications. And I expect Amy kind of hinted at this a little bit earlier, where she talked about doing those kind of urgent applications and explaining to people what the differences are. And I think it's just really important that individuals understand what authority are they actually seeking. And if you're looking to sell property, there's a different piece of legislation for that as well within there. So I think really, if we're training individuals or we're making a specific application, say for trusteeship, that they really read those 2 sections or the entire trusteeship section and make sure that you understand it. And then if you have more questions, of course, consult another lawyer, or at times, lots of people will call our office and ask for clarification or questions on specific sections. We don't give legal advice, but we'll try and give generalities in a response to help them kind of guide them along a direction that's helpful.
Perfect. Lincoln?
I'll just quickly mention 2 things. One, I think the AGTA is, as you mentioned, I was involved in the initial planning and research and all the other kind of fun things that happen when new legislation, particularly one as important as this, is kind of being revamped. So the fact that it has guiding principles about when you're doing kind of substitute decision making, whether it be co-decision making or specific decision making or guardianship and trusteeship, there's some guiding principles at the beginning of the legislation that are very important to keep in mind at all times about, again, preserving the dignity of these individuals. And for me particularly, it's the the fact that these individuals don't have capacity to understand what's going on makes it even more important for those of us who are making decisions and part of the process to safeguard as much as possible the individual's rights, because they can't do it themselves. So it's not like, oh, they don't know what's going on, we can just do whatever we want. No, it's they don't know what's going on. So we have to make sure that everything is being done appropriately, with dignity and all those kind of things. And the other thing is that the legislation contains provisions for the investigation of complaints against trustees and guardians, which our old legislation did. And so that's a new piece, and well, hopefully not it's an important piece. I wish it wasn't used as much as it is, but it is in the legislation, and people should be aware that now, instead of having to make their own court application to challenge a trustee, whatever, there is a mechanism for our office to actually investigate complaints against trustees and guardians.
Excellent. Thank you for that. Amy, from your perspective?
I'll just add a couple of brief things. I agree with everything that Susan and Lincoln highlighted. Those were on my list as well. I think touching on what Susan had said, one of the most important pieces of the Act, I think, is the duties and authorities that are specified for each type of decision maker. So being familiar with those as somebody who's in that role is really important, and good to know that that's right there in the legislation. Another mechanism that's in the Act is the ability for a guardian to apply for, and actually I think a trustee can as well, for advice and direction from the court. There's sort of this broad mechanism to allow a decision maker to get that advice if they need it from the court. It could be, potentially on, difficulties they're encountering in carrying out a duty, or they're unsure of whether or not they can do something within their role. So there is that mechanism there. And for guardians, if they're encountering some difficulty actually giving effect to a decision, perhaps somebody is obstructing that, you can actually apply for the court's direction on that as well, if needed, either because perhaps the represented adult isn't cooperating, or there's somebody else who is interfering with the decision. I think the only other thing I mentioned just briefly, I know we've been talking about guardianship and trusteeship, mostly I think in the context of kind of planning for the future, and talking mostly in the context, I think, of people who lose capacity later in life. And of course, this Act applies as well for people who have never really had capacity from potentially the time they were born or a child, who are becoming adults and need that decision maker appointed. So one thing to note is the Act does allow an application to be brought before, or commenced before, that person turns 18 years old, so that you've got the application underway in the hopes that it will be in place when that person turns 18.
Excellent. Those are all excellent points. Thank you for sharing some of the, more nuanced pieces of the legislation. So I appreciate that. Okay, we have one more question. I don't see one more question in our discussion here. We will have a few minutes for Q&A at the end. So I don't see any questions in there yet. So if you have any burning questions, make sure you pop them in there. But we are going to wrap up our discussion with a question about resources. So what other resources are available for people who are wanting to learn more about the AGTA? And I'm going to start with you, Amy.
Sessions like this are great resources. So CPLEA, of course, I think in past sessions, I've mentioned other legal clinics as well, like the Edmonton Community Legal Center does provide some information and support in this area as well. And then, of course, the Office of the Public Guardian and Trustees website, which I'll let Lincoln and Susan speak to. And then there are some agencies around who also provide some information and support. One that comes to mind is the Seniors Association of Greater Edmonton is one. I believe they still have a form of adult guardianship and trusteeship program. So, it is worth having a look sometimes online to see what's out there locally in terms of providing those supports. And of course, always lawyers are a source of information and advice as well if you think you need that kind of legal advice.
Excellent. Thank you. Lincoln?
Like Amy said, our website is actually not a bad place if you want some background information about the AGTA. And then, of course, there's lots of information about the various decision-making options that exist under the legislation. And as well, we did on YouTube, we did a series of seminars a little while back, but the legislation hasn't changed, so they're still relatively valid, about decision making in the adult guardianship and trusteeship and things of that nature. So that's another place to do. And again, always, from the information calls that we get, we're always telling people to contact a lawyer if they want specific information about their specific situation, which is what everyone always wants, right? We can only tell you the legislation says this, and you have to determine how that meshes with your specific circumstance, and that's what a lawyer would assist you in doing.
Perfect, thank you. And Susan, any last resources?
I don't think I have any last resources. I was actually, Lincoln, as you were talking, I was thinking about those YouTube seminars that you guys had done over the years. That's a really great place to go. And some of the seminars are actually quite long. I'm not sure I have the link right off the top, but I think Lincoln and I can go and look for that for you. SAGE, the question came up about SAGE, Seniors Association of Greater Edmonton. Yes, they still are a resource and they will help individuals type their applications. There is a fee for it, but they will do that. And I don't think I can add anything else. I think we've covered everything.
Perfect. Well, thank you guys for sharing. And we've mentioned a little bit, Natalie's been posting a lot in the chat, some of the websites we've talked about. She did find the link to the Office of the Public Guardian YouTube channel, so that's in there for you, and some of the websites we've talked about. I do want to highlight, of course, some of CPLEA's resources as well. So we do have a booklet on the AGTA that describes some of the different decision-making tools as well. So it's a nice kind of handy paper takeaway if you want. It's also available online. We'll post a link to that booklet in the chat as well. And we have a variety of resources on planning for incapacity and different decision-making tools. So you can find all of our planning for the future resources on our website. If you go to the top corner, there's a little, it'll say legal info and a drop down, and then just choose planning for the future. And you'll find all of our resources about the AGTA, but as well as we've talked about before, making wills, personal directives, powers of attorney, etc. So that's all there. I do want to highlight one website of ours. It's called oaknet.ca. It is the Canadian Law for Older Adults website. Again, you'll see the little planning spot there. I do want to highlight that planning is not necessarily for older adults or not exclusive to older adults. So I don't want to kind of feed into that misconception there, but that website is there with some more resources. And I want to highlight some upcoming webinars. So this has been a great discussion this morning. We have 3 webinars coming up in our webinar series. So look for Renting 101. We're doing an update on the Divorce Act after all the sweeping changes that came in a year ago now. So we're going to do an update on that. And then we'll have a bit of a CPLEA open house on May 18th. So you can register for those the same way you would for this one. I still don't see any questions in the chat, so either we've answered them all, which has been fantastic. I'll leave it open for another minute as I say, just thank you so much to our panelists for joining us this morning. I learned a lot, so I appreciate you taking time out of your day to join us and share your different expertise and knowledge on this topic. So a big, huge thank you from all of us at CPLEA, and yeah, still no questions. And one final thing before we wrap up, though, we do appreciate any sort of feedback you have for us. So we're going to post a link to an evaluation form in the chat. And when you leave today's webinar, you'll be prompted to click through to complete the survey as well. It's just a quick 30-second survey, but it just lets us know how we're doing and if there's something we can improve on. So please make sure that you take 30 seconds to fill that out. I just see one question. Will this list of resources be available in print? What we will do is we'll send out a follow-up email to everyone. You'll get that in about a week once the webinar on demand is up, and we'll have some of the high-level links that you can find most of the information that we've talked about. So we'll address that one question there. Any final thoughts from our panelists this morning? No, everyone's good. Again, thank you so much for joining us. Thank you, everyone who participated and joined us as well through your computers this morning. We appreciate it. We'll wrap it up there. So happy Wednesday, everyone, and we'll see you next time.